Good evening, everyone. My name is Alisa May V. Garcia, and I will discuss Article 1238 to Article 1244. Article 1238. Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent, but the payment is in any case valid as the creditor who has accepted it. So, sa Article 1238, sinasabi, yung payment daw ni third person na wala namang intensyon na ma-reimburse kay debtor is deemed a donation. So, meaning, dahil deemed a donation, kailangan is may consent ni debtor para bayaran yung utang niya kay creditor. If walang consent ni debtor, is deemed a donation lang. For example, David owes Carl 10,000 pesos without the intention of being reimbursed. Sam paid David's obligation. David had previously accepted Sam's generosity. Article 1239. In obligations to give payment made by one who does not have the predisposal of the thing due the capacity to align it, it shall not be valid without prejudice to the provisions of Article 1427 under the title on natural obligations. Predisposal of a thing due means that the thing to be delivered must not be subject to any claim or lien, while the capacity to alienate is the person is not incapacitated to enter into contract. Sa free disposal of thing due and capacity to alienate required, sinasabi naman dyan na ang creditor ay may rights na ma-recover yung bayad or pera, lalo na kung yung mag-aabot or magbibigay sa kanya is walang kakayahan. Like minors nga, yung mga kabataan. Sam agreed to sell to David a television set. If the television set delivered to David by Sam belongs to Carl, the same can be recovered by Carl because the payment is not valid. Sam does not have free disposal of a television set. Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Payment shall be made to the creditor or obligee, which is the person in whose favor in obligation has been constituted. Second, his successor in interest, like an heir or assignee, or any person authorized to receive it. Pag sinabing any person authorized to receive it, pwedeng ito yung person authorized by the creditor, person authorized by the law, which is ito yung mga guardians, executor, or administrator, and assignee or liquidator of a partnership. Example, David owes Carl 1,000 pesos. In this case, David must pay Carl or any person authorized by Carl, or in case of his death, his heirs or any person authorized by law. Payment to any person is not valid except as provided in Article 1241 in paragraph 2. That David acted in good faith in paying to the wrong party is not an excuse. Article 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. If after the payment, the third person acquires the creditor's right. Second, if the creditor ratifies the payment to the third person. Third, if by the creditor's conduct the debtor has been led to believe that the third person had authority to receive the payment. David delivers 1,000 pesos to Carl, a minor under guardianship, in payment of a debt. Carl lost 700 pesos of the money in gambling or due to negligence or ignorance. So in this case, the payment should be considered as made only to extent of 300 pesos. On the other hand, if Carl kept the money paid or spent it for purpose useful to him, the payment shall be valid. Otherwise, Carl would unduly enrich himself at the expenses of David. Article 1242. Payment made in good faith to any person in possession of the credit shall release the debtor. In this article gives another instance when there is valid payment to the third person. It must be observed that the possession referred to under the above provisions in possession of the credit itself and not merely of the document or instrument evidencing the credit. Hence, mere possession of the instrument does not entitle the holder to payment, nor does payment release the debtor. Furthermore, the payer must act in good faith, that is, in the honest belief that he is making a valid payment and that the payee is the owner of the credit. Good faith is presumed. Article 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. When payment to creditor not valid in action against the debtor who is the creditor of another, the latter during the pendency of the case may be ordered by the court to retain the debt until the right of the plaintiff, the creditor in the main litigation, is resolved. Payment made subsequently by the debtor stranger shall not be valid if the plaintiff wins the case and cannot collect from the debtor to whom the payment is made. Such payment is considered as made in bad faith. Article 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obligee's will. In Article 1244, it says dun sa first paragraph, it refers to a real obligation. Real obligation means obligation to give, to deliver a specific thing, and there is no way that debtor may give other thing than that kasi nag-iisa lang yun. With specification, yung bagay na yun na siya lang ang meron, that cannot be found exactly to other thing. Kaya si creditor, may right siya na hindi i-receive yung bagay na binibigay ni debtor. Yung second paragraph naman is same lang siya dun sa first paragraph. But the second paragraph, it refers to the personal obligation, which is pwede mo siyang gawin or pwede mo rin siyang hinding gawin. Substitution can be made if the obligee consent in facultative obligations. The debtor is given the right to render another prestation in substitution. Article 1244 will not also apply in case of waiver by the creditor or substitution is allowed by stipulation with the consent of the creditor.